Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about defamation. Defamation is a procedure for check and balance on the right to freedom of speech and expression. It is a procedure to ensure that nobody harms the reputation of any person or tends to create a wrong opinion of the person who is defamed in the eyes of the public. To make you understand what it really is, suppose there are two party members, Mira and Subodh, standing for election. Subodh says Mira is a corrupt person and I've seen her taking bribes in the past, so do not give her vote. This statement is untrue and harms the reputation of Mira. As no one in the public will give the vote to a corrupt person, this will directly hamper Mira's winning in the election. To prevent this, provision regarding defamation are available in section 499 to section 502 of the Indian Penal Code. In this article, we will understand them in detail. Analysis of the offense of defamation. Section 499 of the Indian Penal Code talks about defamation. So what is defamation? Any person who by spoken or written words, signs or visible gestures creates or publishes any imputation on any person with an intention to harm the reputation of that person, the person making such imputation should have the knowledge or a reason to believe that such imputation will ruin the reputation of the person. However, there are many exceptions included in this section. We will discuss them in the approaching topics. Reputation. To sue any person, it is necessary to establish that real damage or harm has occurred to the reputation of the person. Only speaking or writing the words, picturing or gesturing does not amount to defamation until the reputation of the person has been harmed. Harm to reputation is the only negative consequence that can arise from the act of defamation. It could prove harmful to your professional career as well. For example, if someone pointing out to a shopkeeper says that you should not buy groceries from him as he sells low-grade things at a high rate, in this case, if the statement is found to be untrue, then the reputation of the shopkeeper is being harmed, as this will lead to the shortage of customers coming to his shop. Publication. For a person to be sued for defamation, it is required that the publication of the words he spoke or wrote must have happened. It means that the damage to the reputation of the person happens when the defamatory words have reached to any third person. Publication means that the third person has read, heard, or seen the written, spoken, gestured, or pictured defamatory words. If it has not happened, then there is no ground to sue for defamation. The distinction between English law and the Indian law. An act of defamation can occur in two forms, libel and slander. Libel, it is a kind of defamation that is present in some permanent form such as in writing, printed, or a picture. Slander, it is a kind of defamation that is present in an unwritten form such as spoken words, gestures, or representation made with hand. In English law, there is a distinction between both of the forms under the categories of criminal defamation and civil defamation. Under criminal law, only libel is an offence and not slander, whereas in civil law, libel is an offence just like in criminal law, but the change here is that the slander is also an offence when proved with proof. In Indian law, both slander and libel are recognized as criminal offences under section 499 of IPC. Whereas in the law of torts, libel is actionable per se and slander is actionable. It means in the case of slander, there has to be proof of the act of defamation. D.P. Chaudhary vs. Kumari Manjulata. In this case, it was published in a newspaper that Manjulata, a 17-year-old girl belonging to a well-known family, eloped with a boy who lived close by. After this, her reputation got tainted, and she suffered a lot of disgrace as this news was completely false and was published with irresponsibility. Later on, the court in this case ruled out Rs 10,000 should be provided to the defendant as it amounted to defamation. Forms of publications. There are various forms of publication in which the act of defamation can take place. Direct communication to the defamed. If any defamation is made directly to the defamed and is not heard by anybody else, then it is not defamation. It is necessary that any third party hears it through which the reputation of the defamed goes down. Publication by repetition. There is a limited period to sue for defamation. It is maintainable till 1 year since the act of defamation took place. For a single publication, an action for libel can arise, but for repetitive or multiple publications, the action can arise every time the libel is published. Cover Butt vs. Azir Nazir Mir. This case was decided in the year 2013. The Delhi High Court in this case ruled out to set aside the multiple publication rule on the internet and to follow only the single publication rule. Printed matters, liability of editors and others. Section 501 of the Indian Penal Code talks about the printing of defamatory things. It says that any person who prints or engraves such a matter which he knows or he has reason to believe that such matter is of defamatory nature and hence will lower down the reputation of the person and bring ridicule and disgrace to his or her character. This section checks for the printed defamatory matters and provides the provision for the punishment to the person who printed it. The punishment of a maximum of 2 years in jail or fine or both is proved under this section. Thank you.